a poison or both. In my view, it won't be necessary to deal with the cause of death, as same is not in dispute. The accused's contention, however, is that he admits that he is guilty of murder without premeditation of planning. The state already has rejected the accused's admissions to that effect. Again, the court rejects the version of the accused that he administered the poison on the deceased in order to make her sick for the following reasons. Judging from the toxicologist's evidence, if indeed that was so, he had all time to seek medical help and to save the life of the deceased. Carbaryl, as the toxicologist put it, is not a fast-acting poison in humans. Its effect is reversible and treatable. In fact, Mr. Van Zyl was surprised to find carbaryl in the blood, as it metabolizes quickly. The only explanation if carbaryl is in high concentration is that the person was exposed to high doses and time for it to metabolize. If the accused was really, or his intention was really to make the deceased sick, the child would not have died from poisoning given this type of evidence. The accused, in my view, had other motives that were clearly to commit those crimes. In order to ascertain whether the murder committed by the accused is premeditated or not, it is important to examine all the circumstances surrounding this murder. The witnesses, Joanetta Peterson and Marsha Van, testified about the rocky relationship between the accused and the deceased. This court has already rejected the fact that this might be a valid reason for the accused to rape and murder the deceased. It appears, though, that the accused harbored ill feelings against the deceased mother for a long time. For instance, in paragraphs 8.12 and 8.15 of the accused admissions, he stated the following. 1, irritated for having been woken up the second time and compounded by ill feelings between myself and her mother, I decided to give her end poison. On the second one, my intention was to make her sick, and in doing so, to get back at her mother. Gathering from these statements, the accused has always had an intention to get back at Ms. Pieters. He planned to commit a crime a long time ago. Whether the offenses committed justify such a revenge when the witnesses who testified in court and the accused could not put a finger on the causes of such disagreements is a cause for concern. And I repeat, in my view, it's not enough a reason for the commission of crimes. Further, all the witnesses who resided at 23 Pluto Street testified that there was no end problem in that house prior for May 2017. Ms. Scholes, who conducted the search of the deceased in the accused room, was resolute that there was no end problem in the said room. Also, Captain Taylor was asked if he did investigate this end problem during his investigations. He testified that he did investigate this issue. He has been in that house on numerous occasions during the investigations. Not even a single day did he encounter ants in that house. This therefore brings this court to a question once more of whether the accused was honest when he made his admissions, plea explanation, and confession statements. The accused stated in his confession statement that he wanted to mislead the investigators not to think it was him who committed these offenses. Similarly, the accused wants this court to believe that the ant poison was in the house to get rid of the ant problem, whereas in fact, the reason for the ant poison was for the accused to use it on the deceased or any other person for that matter. As the toxicologist testified, the quantity of carbaryl in the deceased's blood was very high. Further, the accused did not know the effect of this poison on a human being. In the said situation, could the accused be believed if he stated that he wanted to make the deceased sick? The only inference that this court can draw, given the absence of evidence that there was an ant problem at that house, is that the accused intended to kill the deceased. It is so that premeditation requires some planning, and that the accused's actions, in my view, could not be said to have happened at the spur of the moment, as the defense argued. He procured the poison. He waited for the opportune time to execute his plan when the child or children had no adult supervision in the house. He went to mix the poison outside his room in the sink. He gave the poison to the deceased and further threatened the deceased with violence if she didn't want to drink it. He choked her when she wanted to scream. He hit her with an open hand on the forehead and continued to choke her by putting his hand around her throat. If one had to consider what the deceased had gone through before her death, it has been a painful, agonizing, and harrowing experience. This is borne out by the injuries that she sustained in her body that were noted by Dr. Ugo. It is apparent that the deceased went through a great deal of torture before she met her death. The accused had all the time to do as he pleased on the deceased the whole morning. This is proved, the video footage that was presented in this court showed the deceased carrying the body, showed him carrying the body of the deceased to the dumping site shortly after 2 in the afternoon. The accused had enough time to stop his evil intentions if he indeed wanted to, but nevertheless he went ahead. This means that for all intents and purposes, the accused made it a point that what he had planned has to be carried through. It is settled law that planning should not have been done a long time ago. Also, a short time would suffice. In Kekana versus the State Supra, the court held, open quotes, "In my view, it is not necessary that the appellant should have thought or planned this action a long time ago, a long period of time in advance before carrying out his plan. This is not the only consideration because even a few minutes are enough to carry out a premeditated action. In this matter, the circumstances were such that the planning and carrying out the premeditated action were achieved. The inference to be drawn is that the accused had manifested a plan to commit a crime and succeeded in doing it. See Moncho versus the State Supra. It might be that the expert witness that was called by the defense downplayed what was typically the injuries that were suffered by the deceased in this ordeal. Dr. Naidu blamed all the defects in the deceased's body to hemolysis due to decomposition. For instance, the injuries that were described by Dr. Ogle and Professor Dempers as abrasions were identified by him as shed blisters. At the same time, Dr. Naidu was non-committal about the basis of his opinion. Highly disturbing, the pronounced dark marks on the forehead, eyes, upper cheek, and upper lips, which is patently clear that it resulted from an application of blunt force, was described by Dr. Naidu as a random color change and was in keeping with the greater bacterial proliferation. Dr. Naidu maintained his opinion despite being reminded that the accused admitted hitting the deceased with an open hand, closing the deceased's mouth with a towel and choking him. Surely this would require an amount of force from the accused to shut the deceased down. Dr. Naidu's response was that he drew an objective inference, having kept the accused version on the background. The principles governing assessment of expert evidence are the same both in civil and criminal cases and are set out in Schreider versus AA 2010, in brackets 5, SA 205, CC at 211E, where Davis J. observed, open quotes, in Zeffert, Pazes and Scheme, the South African Law of Evidence at page 330, the learned authors citing the English judgment of National Justice Compania, Naviera SA, Prudential Assurance Company Ltd, in brackets the Icarian River, close brackets, in brackets 1993, 3 Lords Reps 68 at 81, set out the duties of an expert witness. Thus, number 1, expert evidence presented to court should be seen to be the independent product of the expert, uninfluenced as to form or content by the exigencies of litigation. 2, an expert witness should provide independent assistance to the court by way of objective, unbiased opinion in relation to matters within his expertise. An expert witness should never assume the role of an advocate. An expert witness should state the facts or assumptions upon which his opinion is based. He should not omit to consider material facts which could detract from his concluded opinion. An expert witness should make it clear when a particular question or issue falls outside his expertise. If an expert opinion is not properly researched because he considered that insufficient data is available, then this must be stated with an indication that the opinion is no more than a provisional one. In cases where an expert witness who has prepared a report could not assert that the report contained truth, the whole truth, and nothing but the truth, without some qualification, that qualification should be stated in the report, close quotes. Sorry, still open quotes. In short, an expert comes to court to give the court the benefit of his or her expertise. Agreed. The expert is called by a particular party, presumably because the conclusion of the expert using his or her expertise is in favor of the line argument of the particular party. but that does not absolve the expert from providing the court with an objective and unbiased opinion based on his or her expertise as possible. An expert is not a hired gun who dispenses his or her expertise for the purpose of a particular case. An expert does not assume the role of an advocate, gives evidence that goes beyond the logic which is dictated by the scientific knowledge which that expert claims to possess. Close quotes. In my view, when an expert comes to give evidence, he or she should stick to the principles as laid down in Schneider Supra. This court was presented with evidence, most of which was scientific in nature. In my analysis, the expert evidence provided by the state cannot be faulted. From the toxicologist, a DNA expert, medical technologist, and pathologist. Their evidence was independent, objective, and unbiased. Then, coming to the parallels of the two pathologists, that is Professor Dempers and Dr. Naidu, the two experts seemed to be at odds with each other. Frankly, this court understood the role of an expert or expert witness clearly when Professor Dempers testified as a witness. The wheels started to turn when Dr. Naidu testified. In my mind, it was clear that Dr. Naidu was a hired gun who dispensed his expertise for the purpose of the accused case. Dr. Naidu's evidence was tailor-made to suit the explanation of the accused. For instance, that he committed sexual intercourse with a corpse. He continued to advance the opinion that the injuries, if any, that were sustained by the deceased in her genitals and on the entire body were post-mortem, even after overwhelming scientific evidence to the contrary from the DNA expert, Dr. Ogle, the pathologist who performed autopsy, and from Professor Dempers, who performed immunohistochemistry stain test. Given the fact that both experts were from the same field, this court expected them to agree on a number of issues, and concessions be readily made where possible. Dr. Naidu, in my view, came to court with a fixed mind, and in the process assuming the role of an advocate. However, in accepting the evidence of Professor Dempers, this court examined both expert witnesses and analyzed their essential reasoning based on the surrounding circumstances of this case. The approach to the expert evidence has an established rule and is laid down in Michael and another versus Linksfield Park Clinic Pty Ltd, and another 2001 in brackets 3 SA 118 at 111200 at paragraph 36, where the court held that being so, what is required in the evaluation of such evidence is to determine whether and to what extent their opinions advanced are founded on logical reasoning. The evidence of Professor Dempers, in my view, assisted the court tremendously as it went further to uncover the evidence that was obscured by decomposition. The application of glycophorin A as a novel phenomenon and a specialized technique ultimately proved that where Dr. Ogle noted contusions and lacerations on the vagina, there was indeed blood. Professor Demper's evidence in its entirety was logical. Now, to the extent that it might be said that Ms. Pieters abused and or neglected the deceased by leaving her alone in the house with her 6-year-old brother, Adrian, this court is equally alive to the economic status of Ms. Pieters. Ms. Pieters left the children alone so that she could afford to put food on the table. She left the children alone in order to earn a living. Unfortunately, Ms. Pieters' children, especially the deceased, suffered the consequences of being born in a society that is poverty-stricken. This mother had to leave them unattended as she could no longer afford to pay Ms. Venn in order to attend to the job for their sustenance. The accused, on the other hand, was present in this house. He was not a stranger to the family, but he abused their trust. He was part of this family unit as the parents and the deceased developed some level of trust when he was around. Little did the family know that the accused would be the main perpetrator of these crimes. Even after he committed these crimes, he kept quiet for days and went about with the search parties to look for the deceased, knowing very well what he did to her. He, in fact, agreed with the members of the community when at some stage the number one suspect was said to be one Richard Maxim. Had there been no discovery by Ms. Skoll's search party, accused would have continued with his life and said nothing. The behavior of the accused in this entire period is the most vicious, brutal, inhumane, ruthless, sanguinary, and painful this court has ever seen. After observing the mother of the deceased reliving what happened to her last-born child through her testimony in court, the lack of professional support, the emotional effect of this whole ordeal, and the impact it had on her health, it would not be just for this court to add an element of prosecution, more so after the deterioration of her health. In any event, Ms. Pieters showed some remorse as she was deeply hurt. She took responsibility for leaving the deceased without adult supervision. Ms. Pieters is therefore granted immunity from prosecution. In the result, Ms. Pieters is discharged from prosecution in terms of Section 204, in brackets 2, of the Criminal Procedure Act. Ms. Saunders, stand up. In conclusion, after careful consideration of the totality of evidence that was presented in this court is therefore satisfied that the state has proved its case beyond reasonable doubt. In the result, we are found guilty on count 1, that is rape on the main count. Number 2, we are found guilty on count 2 on murder on the main count. Argument on sentence. Just a second. I don't have a bench book with me to note what you're saying. I don't have a bench book, sis. We're going to write at the back. The state notes no previous convictions. that the SAP 69? Okay. The last time I see. The exhibit would be marked as Exhibit DD. Do you agree, Mr. Kalitz?
Well, at this stage, I'm going to ask that the pre-sentencing report be prepared. My understanding is that it takes a minimum of 4 weeks.
I thought I would be done with this case this year, still.
Well, we are trying to push for the 3rd of December. That is a minimum period. It takes between 4 and 6 weeks. We are looking at the minimum period being the 3rd of December. My understanding is that that office will only become involved once there has been a conviction. So one cannot
judge the outcome.
Unfortunately. And only once there is a conviction and we ask that it be done, then it takes a minimum of 3 or 4 weeks, which more or less takes us to the 3rd of December.
I wanted by that time to be done with this case, but
well, then it might, if the report is ready, that is the last week of the term. It takes
the last week of term is the week of the term ends on the 14th of December.
Then it's a second, it earns that week. But if the report is ready, we might be able to finish or finalize this matter by the end of this year.
Let me ask Ms. Yeah. What type of evidence are you going to be presenting? Sorry? In aggravation. Oh. In the form of? Victim impact. Sure. So when do you think you'll be able to finalize that?
Well, I heard of the defense stating in respect of the pre-sentence report. I would have suggested that the matter be postponed until the end of November because I foresee that I will be ready at that stage.
I heard you last time you said you were going to the circuit court.
Yes, but I am going to the circuit court, next week from the 12th to the 30th of November.
Well, the 30th of November is the preceding Friday, the 3rd of December. So it takes us to the 3rd of December. The next full day will be the Monday.
I can have some record that the circuit court matter will be in terms of 105A, which will be finalized next week.
In one day. That will finalize in one day. Okay. So you won't be staying there.
Yeah, I will be available the last week in November.
So can you postpone the matter then to the 14th for that purpose to see if all reports have been prepared?
Well, then I'm in relationships hands. My difficulty is, on average, unfortunately, it takes a minimum period of 4 weeks. I'm happy to postpone the reported period, but that is obviously without any undertaking that the report will be ready on that date.
It should be ready.
I'll take into account the shortest period possible, and that take us to the 3rd of December.
Let's do 4th as the provisional date then.
The 4th of December.
Yeah. We'll reassess on that day whether all the reports have been gathered. 4th of December. Mr. Saunders? Is it possible not to make noise, please? Due to the fact that your council has to procure a pre-sentencing report, and also the state has to procure a victim assessment report, the arguments of this matter would not happen today or in the near future. So we have to postpone for that to happen. So the matter is postponed up until the 4th of December. We are warned to be in court on that day. Cora Jens.
All right.